Mr. Quinn?
Yes, Your
You are
Honor.
the appellant. You can proceed.
Thank you, Judge Valenti. May it please the court, John O'Quinn on behalf of the appellant, Dr. Burkhart. I'd like to reserve 5 minutes for rebuttal.
All right.
The core issue in this appeal is whether, in the context of this breach of contract action between Dr. Burkhart and Arthrex, Arthrex can use the lawyer-client privilege not as a shield against discovery into its own communications with its own attorneys, but as a sword against Dr. Burkhart's reliance on communications that he and his attorneys had with Arthrex and its lawyers. The trial court's decision that it can was the sole basis for its order disqualifying Dr. Burkhart's counsel for having reviewed some of Dr. Burkhart's own files in responding to Arthrex's document requests. That decision cannot stand for at least 3 independent reasons. First, these were classic communications between arm's-length third parties with their own separate interests, some common, some adversarial, who were represented by separate counsel. These are not traditional lawyer-client communications. I mean, to state the obvious, Dr. Burkhart is certainly not Arthrex's lawyer, and Arthrex insists that Dr. Burkhart was not the client of Arthrex's lawyers either. Instead, what these were contractual counterparties to a business arrangement. And that is why Dr. Burkhart's own lawyers were involved. And so whatever you think of Dr. Burkhart, certainly Dr. Burkhart's lawyers were not included on these communications to advance Arthrex's legal interests. They were included because Dr. Burkhart demanded it when he was concerned about being wrongly denied royalties. And I encourage you to look at pages 550 to 551 of our appendix. It's one of the most important documents about the nature of the parties' relationship. Now, to be sure, the law does recognize an exception to protect communications where third parties who share a common interest in a legal matter can communicate among themselves but retain a privilege as to the outside world. As cases such as A.G. Beaumont and Visual Scene recognize, and as the Florida Supreme Court held in a case called Tunador, 221 Southern 3rd at page 602. But those communications among the parties who share the common interest, while they may be privileged as to the outside world, they're not privileged as against each other.
So at the heart of your argument is that Dr. Burkhart was not the client of the Arthrex attorneys, nor was he an employee or an agent or a stand-in like some of these other cases would indicate might qualify one to take advantage of the attorney-client relationship?
That's exactly right, Judge Black. And while he certainly shared a common interest with Arthrex in some respects, and so as a result, he and Arthrex could each potentially take advantage of their common interest to protect their communications from the outside world. And so all of the policy concerns that Arthrex has identified about inventors and attorneys needing to be able to talk in some circumstances without the outside world learning about that's all protected by the fact that they would have shared a common interest in at least some respects. But what it doesn't do is then allow one of the parties to essentially to claim privilege over their communications to the exclusion and to the detriment of the other party.
Now, is it true that is it accurate that the privilege was not claimed until after the discovery was delivered by Dr. Burkhart?
That's exactly right, Judge Black. I mean, just to be clear, in terms of sort of some of the sequence of events here, Dr. Burkhart and Arthrex had been communicating with Dr. Burkhart's prior attorneys for. Should I pause? It looks like my opposing counsel has disappeared.
Yes, I don't see him either.
Yeah, let's I'll stop the clock. Let's wait a minute and see what happens. He had his mic on mute. Not that that matters. If it's still on mute, he won't be able to talk if he can't be seen.
Judge Valenti,
Yes.
it looks like he may have disconnected. So if you give us just 1 second, we'll give him a quick call.
All right. Okay.
The clerk's office is trying to contact him, sir.
Yes. Thank you.
So it looks like, Judge Belanti, it looks like he's come in as a phone caller. Can we just allow him to talk and see what's going on?
Of course.
Okay, he should be able to talk now.
Mr. Bender, can you hear me?
Yes, Your Honor, Marshall Bender. My apologies. My computer just died.
Okay, so
During,
we lost the video. What's your pleasure? You can proceed without us seeing you, or you can come back another day. I'm not sure what the options are with or find some other equipment at your location.
Your Honor, if you could give me about 10 minutes, I think I could find alternative equipment to log on to the
All right.
Zoom so we could be back on. I apologize.
Well, it's
Your Honor.
okay. It's okay. We'll
Yep.
work with you. I think we will give you the 10 minutes. We'll take a 10-minute recess. But if you get it done sooner, then the bailiff will let us know. We'll start sooner. So I guess everybody's on standby, but I'm going to take my video off and put my mic on mute. And everyone's welcome to do the same thing if they want to.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Did I log in on yours?
Mr. Bender, you're still on the phone. You can mute it if you can.
Yes, Your Honor.
Mr. Bender, can you hear me?
Yes, yes, we can hear you.
Okay, I'll go back in and summon the judges back that we can start court again.
Okay, thank you very much, sir.
There you go. Here's some. All right. You can adjust, make sure the volume they can hear you. That'll message it.
Yes,
Can you hear Mr. Bender?
Yes, Mr. Bender, we can hear you. I'm just trying to get the judges to come back up so we can go live again. We are just waiting on the presiding judge.
Okay. All right, we're ready. Thanks for the correction. So, Mr. Bender, you're back. Mr. Quinn, you're in the middle of your argument. You're about at the 15-minute mark, so I'm going to start the clock, okay?
Okay, thank you, Judge Valenti. So when we recessed, Judge Black, you were asking me, was it in fact the case that the first assertion of attorney-client privilege by Arthrex was in January of this year after the document production by Dr. Burkhart was complete? That is correct. And what I was about to do was give you just a little bit of the history leading up to that, because I think it's noteworthy. You can look at Appendix 559 and 636 of our appendix. There was never a suggestion to Dr. Burkhart from Arthrex that he was participating in Arthrex attorney-client communications. And indeed, to the contrary, once his own lawyers were involved, they were not only privy to his prior communications, but they were actively participating in the communications. And the lawyers from Hush Blackwell were also adversarially dealing with Arthrex, as you can see it reflected at Appendix 815 to 817. And then in terms of Kirkland's involvement in the case, Kirkland was involved and sent a letter to Arthrex in February of 2019, in which it made reference to communications that had occurred between Dr. Burkhart and Arthrex's outside patent counsel. And a year later, in February of 2020, when the first complaint was filed in this case, it makes reference to such types of communications in the context of inventorship. And Arthrex, again, said nothing to police its alleged privilege. And so this is not a typical employee situation where they're under the control and direction of Arthrex. They are in a business agreement. They are arm's-length parties to that business agreement. They each have their own ownership interests in their communications, and their agreement to keep communications, these business communications, confidential as to the world was a mutual agreement. It was not an agreement that was one-sided or in one direction. So our position, Judge Black, is that, number one, there is no privilege that attaches here in the first instance, unless it is a common interest privilege, at which point it doesn't apply as between the parties. Second, for the reasons that I was just talking about in response to your question, that if there were a privilege that could have attached here in the first instance, that it's been waived multiple times over, both in terms of the communications to from Arthrex's lawyers to the Hush Blackwell attorneys, the awareness of what Kirkland was doing, and indeed the awareness of what Kirkland had to do in responding to Arthrex's own document requests, which called for communications between Dr. Burkhart and Arthrex, and specifically defined Arthrex as including all of Arthrex's agents, for example. You can see that at Appendix 515. And they specifically asked for, quote, all documents which refer, regard, reflect, or relate to Dr. Burkhart's disclosure of inventions or designs to Arthrex, end quote. That's Appendix 530. Well, who did they think those were going to come from? Because the communications that Dr. Burkhart was having with Arthrex on those topics were with its in-house counsel, its general counsel, its in-house IP counsel, and indeed communications with its outside patent counsel as well. So they knew full well what the communications were that they were having with him. And indeed, these weren't communications from the distant past. They were continuing to have those same types of communications with him, even after this lawsuit was filed, as you can see at Appendix page 475.
Well, I have a question. The judge did an in-camera review, but the order doesn't have any explicit findings or factual determinations.
So Judge Valenti, just to clarify the record, the judge did not do an in-camera review. So he rendered his decision. He ordered Dr. Burkhart's attorneys disqualified, and he said that then he would have to look at the documents. Now, for that reason alone, the disqualification order at a minimum has to be vacated, and the case in fact.
Just clarify, are you saying the in-camera review was not done prior to the ruling, or it still hasn't been done?
As far as I know, Judge Valenti, it still hasn't been done, but it was
I read the
unquestionably
transcript
not.
from the hearing, and he indicated that he was going to do going to do an in-camera review, but then he went ahead and ruled before he ever actually undertook to do one. I don't know whether he ever did or not, but it looked like he was listing towards doing one at the time of the hearing, but then ultimately ruled without it.
That's right, Judge Black. He entered his ruling. He received the documents from Arthrex after the fact. I'm not aware of any review having occurred, or to the extent that it has, that it's been indicated on the docket. Our position was always that you could both reject their claims of privilege, that is, that the trial court could reject their claims of privilege and certainly deny the request for disqualification without ever looking at a single document, because it's undisputed as to who these documents are among. They're with Dr.
Is it accurate that the privilege being claimed was actually over documents, that these are not inadvertent disclosures, these are intentional disclosures over the years between Dr. Burkhardt and the corporation Arthrex?
That is 100% accurate, Judge Black. That not a single one of the.
And the privilege was also over documents that actually were produced by Dr. Burkhardt and Arthrex. The same documents that had just gone out within the last couple of months, there was now a privilege being claimed over those documents. Is that accurate?
Well, just to be clear, these were the documents that Dr. Burkhardt had in his possession for years. They were produced in
response to a production request.
In response to Arthrex's production request. That's right.
And then following that, the privilege is claimed following that production.
That is exactly right, Judge Black.
I got it.
That's
Thank
exactly right. And so I'm sorry, go ahead, Judge Atkins.
Oh, finish your thought.
I was just saying, as I was making reference to before, when they issued their request for production, there can be no doubt that they knew, number one, that Dr. Burkhardt had in his possession communications with Arthrex's attorneys, and that number two, their request for production called for those requests. And if you look at the requests for production, which are in our appendix and which I cited to a moment ago, they knew how to ask for non-privileged information. They didn't say a word to remotely suggest that they believed that they had a privilege over documents in Dr. Burkhardt's possession that Dr. Burkhardt's own lawyers should somehow not be able to see.
I want to distinguish again between what may be more than one argument you're making. I can understand why, and I understand a further distinction between two concepts I'm about to talk about. One is delay, the other is actions taken, and they are obviously intertwined. But I can understand why delay in asserting a privilege might be a factor in determining whether the party asserting the privilege intended the communications to be confidential under the statute. But you also seem to be making the argument that delay could itself constitute waiver in the manner of a Laches type argument, in which what would be attorney-client privilege communications could be waived, the protection could be waived by a holder of the privilege who sat on his rights. Are those two separate arguments?
Well, I think they are. I mean, there are cascading levels of arguments on why we should prevail, any one of which is sufficient for this.
But is there case law that supports, well, let's say we or members of the panel don't decide that the delay was pertinent to or supported that the, as I see, it could be argued, pertinent to support that the holder of the privilege, the purported privilege, never intended them to be confidential under the statute. If we rejected that, is there a case law to support that? Well, which would mean that they are attorney-client privilege because they're confidential and were intended to be so. Is there a case law to support that failure or delay in asserting the privilege is itself a waiver of the privilege?
Sure, Judge Atkinson, I think when you're aware that somebody has possession of the documents in question and that they are indeed looking at least some of the documents that they are now asserting are privileged. That is, the letters, for example, from 2019 make reference to communications between Dr. Burkhardt and Arthrex outside counsel, then they're on notice that those documents are being reviewed if they believe that they have a privilege that would somehow attach here and that would somehow prevent Dr. Burkhart, despite having rightful possession of them, from having his own attorneys review those, then I think that they have waived if they don't affirmatively assert it. And certainly a number of the cases that we
No, I
cite.
just heard that.
Oh, okay. 'Cause I thought you said.
Florida State and Georgia, and he went to Jackson State.
Hey,
I'm
Chad,
sorry, we're getting some.
you're not muted.
We have some background noise. I'm not sure what that is.
It's exactly what we we're just talking
Hold
about.
on.
a while
Hey,
ago.
Ted, is that
You
you
got some
talking?
linemen though. You
Ted,
got a few 4-stars.
Ted,
Yeah.
we have some background noise.
Yeah,
What I saw.
you got an offensive lineman 4-star. You got a 4-star tight end too.
Hold on. I don't know if they know what's going on. I'll stop the clock for a second. Okay. Everybody back to silence is golden routine? All right, I'll restart the clock. Let's go.
Okay, so Judge Atkinson, I think we cite a number of cases in our briefing for that proposition. We also cite them for the independent proposition that delay in moving for disqualification is a waiver of the right to seek disqualification, which is separate and apart from the privilege issue. But just to come back, I want to be clear, even if you think that the parties agreed that these documents would be kept confidential, and certainly there's no dispute that they had an interest among themselves, that doesn't mean that there's an attorney-client privilege here that belongs to Arthrex to the exclusion of Dr. Burkhart. Instead, what that would mean is that we're in the classic heartland of what's commonly referred to as common interest, which is well recognized in this state, and it's
Yeah,
very well.
could I interject? And you're about to answer my question, and I cut you off, but I'm not sure you were going to answer, because before you answer, I want to say I want you to parse out, this common interest doctrine and whether that is the same concept described in 4E, and because I see is 4E an exception to privilege, or is an exception to waiver, and is 4E the same thing as your common interest doctrine? Could you kind of parse that all out and perhaps delineate it for me?
Yeah, can I just give you a heads up before you start parsing that out? You've got 5 minutes, which you want for rebuttal. You're at the 5-minute mark, but I'm going to give you an extra minute because that was a question that deserves an answer. So I won't count the 1 minute extra. Okay.
Sure. Thank you, Judge Valenti. So just to be clear, I mean, I think that if you look at Professor Earhart's treatise in section 502.5, recognizes that section 90.502 codifies what he refers to as the pooled interest or joint defense privilege. And as he reasons it, he says, quote, if the parties later become adversaries, and this is in a situation where we're communicating with a co-party or a co-party's lawyer, he says, quote, if the parties later become adversaries, then section 90.5024C provides that the privilege will not be applicable in any controversy between them, end quote. Now, I know that 5024C is most obviously addressing the joint.
Now E.
I'm sorry. I meant 4E. I misspoke. I meant 4E. I apologize. Thank you, Judge Atkinson. That with respect to 4E, that it most obviously codifies the exception when you're dealing with the joint client situation where you have two clients of the same lawyer. But again, the courts recognize, and again, it's Tudor, A.G. Beaumont, Visual Scene recognize number one, that Florida does accept and acknowledge that parties can have a common interest and to be protected against the world. And number two, that it wouldn't be protected against each other. Because if you take the argument to the illogical conclusion, well, I don't see what Arthrex is to do here either. After all, these communications, many of which are with Dr. Burkhart's lawyers, include Arthrex. And it was in furtherance of Dr. Burkhart, of representing Dr. Burkhart. So are they now disqualified because they've seen such documents and doing their own document review? Of course not.
Mr. O'Quinn, you can keep going if you don't feel like you've completed your answer, but you're at the 4.5 minute mark. If you want that for rebuttal, I can save it for you.
Thank you. Just the final thought in response to Judge Atkinson is to say that that it's well recognized that, of course, that when parties who would otherwise be privileged parties come into conflict with each other, that they can use their communications with each other. Otherwise, the law just simply wouldn't work. I reserve the rest of my
All
time.
right,
for
I'm
rebuttal.
gonna say, I'm gonna round up and give you 4 minutes.
Thank you,
Mr.
Judge
Bender,
Blanchard.
you've got 20.
Yes, Your Honors. Marshall Bender with the law firm of Denton's, Cohn and Grigsby on behalf of Arthrex, the appellee. An initial matter, I'd like to apologize to Mr. O'Quinn and the panel for my technical difficulties, such as life.
Don't mention it. Don't mention it.
I won't mention again, Your Honor. Your Honor, we're here this afternoon asking this court to affirm the ruling of the trial court below, which disqualified the law firm of Kirkland and Ellis from representing appellants in this action. The trial court disqualified Kirkland and Ellis because that law firm reviewed documents and communications requested, protected by the attorney-client.
How do you know that's what the trial judge was thinking? The order doesn't really say that, does it?
Your Honor, I think we certainly can glean that from the order. If we look at the court's order, paragraph 1 says plaintiff's counsel shall return all 1A says plaintiff's counsel shall return all privileged material. B, plaintiffs are barred from using the documents identified in the privilege log. And C, the law firm of Kirkland and Ellis is disqualified. And candidly, Judge, Your Honor, the sole basis for the disqualifying motion was the review, of attorney-client privilege documents. But Your Honor, it's not only was it the review of the documents, the timeline here is important. We've heard appellants talk a lot about delay here. There certainly was delay, but I don't think it's the delay appellants are referring to. We briefed the timeline in the papers, but I think it's worth reviewing again. On January 7th of this year, appellants informed Arthrex that they had substantially completed their document production. About a week later, on January the 15th of this year, Arthrex identified and raised the privilege issue with appellants for the very first time. Rather than stopping everything, rather than sequestering the documents and coordinating with Arthrex or seeking judicial review of the issue, instead, appellants continued to review the documents in issue. They sequestered only 30 documents, refused to return them.
Doesn't the Kirkland and Ellis firm have an obligation to look over whatever documents are being asked for in production? Do they just have to unilaterally take Arthrex's word that these are privileged documents and they can't even look at them? I mean, these are documents that were not inadvertent disclosures. These are documents that had been accumulated by Dr. Burkhart that were his possession over a number of years. And now this privilege is being asserted, and Kirkland and Ellis has been in the case for a couple of years. They got involved in 2019. Don't they have an obligation to review a production request? How can they be disqualified for doing that?
Your Honor, I don't think it's the initial review of the discovery request. Certainly when the discovery request comes in, the law firm will work with its clients to identify responsive documents. There's a first line of defense that appellants Kirkland and Ellis should have, when they saw the attorney-client privilege communications, identified the issue with Arthrex so that the parties could address it. But even if they didn't, we'll give them the benefit of the doubt on that issue. When Arthrex raised the issue with Kirkland and Ellis in January of this year, they certainly should have stopped the review. They certainly should have put those documents to the side, sequestered them unless and until the parties could reach an agreement with respect to how those documents should be handled, or go to the court and have the court make an adjudication. Instead, Kirkland decided to disregard Arthrex's concerns for a period of 40 days.
They went to court, and ultimately nobody even looked at the documents. There was no in-camera review. And as a second prong of this inquiry, doesn't Arthrex have to show that some sort of advantage was gained by Kirkland and Ellis, that action was taken to their detriment? I didn't see anything like that in the record.
Well, Your Honor, I think that's a decision for that the trial court is best positioned to make. There's no dispute. I think the briefs of the parties confirm that Kirkland, the documents reviewed by Kirkland were relevant to the dispute, that they reviewed the documents and kept them for weeks. And they never disputed that they incorporated the relevant documents into their case strategy in this matter.
Now, there's no dispute that these documents were not inadvertent disclosures. These were intentionally given to Dr. Burkhart over the years through his relationship with Arthrex, which has been going on since 2008. Correct?
Correct, Your Honor. What these communications were, and I should take a moment and talk about what exactly is on the privilege log. There are 1,576 entries on that privilege log, all pertaining to confidential communications between Arthrex and Dr. Burkhart, relating solely to patent prosecutions for
How is
inventing.
that privilege? Dr. Burkhart is not an Arthrex employee, and he's not represented by Arthrex lawyers. I don't see how that's even privileged from the get-go.
Well, Your Honor, we cited multiple authorities in our brief holding for the proposition that communications between the owner of a patent and its inventor, those communications in the patent prosecution process are in fact privileged, protected by the attorney-client privilege.
Attorney-client privilege. So this little the colloquy has raised a question, or is illustrative of what I believe is a confusion of the support for, I don't even want to say privilege, but the prohibition on the use of these documents, the disqualification counsel. From what does the privilege derive? Is it the confidentiality agreement, or is it the attorney-client privilege? And let me ask you why I'm asking that. In the confidentiality provision, Dr. Burkhart is not a third party. So the confidentiality provision is a provision that's mutually beneficial to the parties, into which they both agreed, and they agreed that documents to which they are both privy, presumably their agent attorneys could also be privy, are to be prohibited from disclosure from third parties. But it sounds to me in your briefing and just in your argument a minute ago that you're using that confidentiality agreement to support what would otherwise not qualify as a confidential communication under 90.502 as an attorney-client privilege communication.
Your Honor, if that's what it sounds like, that's not what I'm trying to convey.
So which is it? What is this, attorney-client privilege under 90.502, or is this a violation of the confidentiality provision?
Attorney-client privilege under 9502 is what we're looking at here. The confidentiality
is the confidentiality agreement a necessary but not sufficient component of your argument that these communications are confidential and privileged under 90.502?
The presence of the confidentiality provision certainly supports the argument that the communication.
How does it support the argument if the confidentiality agreement considers Mr. Burkhart not to be a third party, but your argument under 95.02 seems to rely on Mr. Burkhart being a third person? In other words, a third person to whom disclosure is in furtherance of rendition of legal services, or for whom it was reasonably necessary for the transmission of communication. Is he a third person or not?
I believe he is under the statute, Your Honor.
But he's not a third person under the confidentiality provision. I just find that it may be a case of never the twain shall meet, yet I'm very confused about how you use the confidentiality provision to support entitlement to the privilege under the statute.
Right. And the focus should not be on the confidentiality provision, Your Honor. We're focusing on the case law and the authorities which provide that these kind of communications between a patent owner and an inventor are protected under the attorney-client privilege. We referenced the opinion in the Larson case, the Middle District of Florida opinion.
Yeah, but in the Larson case, you have an employee. In the Hershey case, you have an employee. In the Abilify case, you have someone who stood in the shoes of an employee. In the Beater case, you have the functional equivalent of an employee. I mean, that's a whole different deal from this, where Dr. Burkhardt is essentially in the role of a watchdog. He's not an employee. He is monitoring these inventions to make sure that he is being treated properly. I know that's not the whole purpose of it, but he stands independently with his own lawyers as a check and balance, so to speak, is the way I think of it, as opposed to these other cases that you cited, and I read them all, where you've got this employee-employer relationship. If Dr. Burkhardt worked for Arthrex, I think you'd have something, but since he doesn't, I question it.
And Your Honor, respectfully, we don't agree that Dr. Burkhardt's role here was essentially serving as a watchdog of his own
Well, that was
interests.
oversimplified. I understand it's been a multi-year, very successful cooperation between the two. I understand that, but that doesn't make him an employee.
And Your Honor, I think the authorities that we cited in our briefing does not, the focus on where does the privilege apply? What kind of communications are protected by the attorney-client privilege? Those holdings don't dwell on the attorney on the employment status of the individuals at all. In fact, I think if you look at the Abilify case, that was a separate marketing firm who was performing consulting services to the lawyer in order to communicate what was going on there. And the court viewed that even those communications were protected by the attorney-client privilege.
Okay, but let's focus on what it seems the statutory privilege does rely on, and that's the intention of the holder of the privilege. And again, I believe your arguments are inconsistent. So in other words, you're arguing that Mr. Burkhardt was intended merely to be a third person to whom disclosure was only in furtherance of the rendition of legal services to the client. And that's totally inconsistent with the confidentiality agreement and the royalty agreements as a whole, in which he's not a third person at all. He's not even a third person. He is an arm's length party to a contract. So those are, I'm just playing the devil's advocate here, but those are incompatible readings. Those two, his let's say his role under the royalty agreement and the confidentiality agreement are incompatible with the role you want to portray him as under the statute, as one who is intended only to be a third person to whom discovery is in furtherance of the rendition of legal services to Arthrex.
And respectfully, Your Honor, I don't know that I agree with that characterization of Dr. Burkhardt's role underneath the respective agreements. Pursuant to those agreements, he assigned all rights and titles to the invention and the right to pursue patent protection for the inventions to Arthrex. Arthrex was the sole party who was entitled to seek patent protection for the inventions that Dr. Burkhardt provided. In order to do that, Arthrex's attorneys, in order to provide legal services to Arthrex, had to reach out to Dr. Burkhardt to gain pertinent information regarding whether or not this was a prior art or how to address concerns raised by the patent office when prosecuting the patents here. And so I don't know that that characterization is correct. The confidentiality provision deals with a lot more than these communications. It's a lot broader than what we're talking about here. What we are talking about here are communications with Arthrex lawyers with Dr. Burkhardt that were for the sole purpose of rendering legal advice to Arthrex with respect to the prosecution of various patents for which Dr. Burkhardt was the inventor.
So let me talk about that for a second. So these are communications with Dr. Burkhardt. So what of the characterization by the appellant that these are not attorney-client communications that Burkhardt learned of, but rather these are communications to and from Mr. Burkhardt, and which included Arthrex's attorney? Does that distinction matter?
I don't know that it does, Your Honor. I think when we look at the case law, those documents are still protected. Essentially, what Dr. Burkhardt is alleging is that there is a waiver of the privilege by disseminating.
Well, those are two separate arguments in my mind. So I'm just giving you insight, whether that's helpful or scary or both, I don't know, but insight into my mind, which is those are two separate arguments. One, which is it a confidential document under 90.502B, which is required for it to be an attorney-client privilege document? And two, if it is, whether that was waived. And I personally, right now, I'm thinking about the first question. Was, if we were to look at the documents, which obviously we can't, except for the cryptic excerpts you provided, would we find, or would that they reveal an intent by Arthrex to disclose only to third persons to whom disclosure is in furtherance of rendition of legal services to the client? Or was these actually just conversations among a group of people who were trying to get patents approved? And they happen to include actually some of them both parties' clients.
Your Honor, the documents that are included on the privilege log that Arthrex filed in the trial court are solely those seeking information from Dr. Burkhardt to further Arthrex counsel's legal advice to Arthrex. It's not just simple communications. We talk in our brief a little bit about what is not in the privilege log. Communications relating to discussions with Dr. Burkhardt and Arthrex engineers or things of that nature. Those are not covered in our privilege log.
Let me ask you this. So let's say I'm a criminal defense attorney and I am reaching out to a potential witness and on behalf of my criminal defendant client, and that's in furtherance of rendition of legal services to my client has been accused of a crime. And I email this potential witness, and that potential witness, talks to his lawyer and says, "Hey, should I answer this? Should I plead the fifth? Whatever." Is that a violation of attorney-client privilege? And then could that even be adduced at trial? This whatever was that conversation itself. In other words, it is, as the appellant asked in its brief, is any communication with any third party, as long as it was in furtherance of rendition of legal services to the client, an attorney-client privilege document?
Certainly not, Your Honor. Certainly not.
So what's the distinction here?
The distinction is the function of the communication. What was the purpose of that communication?
Yeah, well, it sounds like it's the same purpose in both, at least as far as the what I just quoted from the statute, which is they were both in furtherance of the rendition of legal services to the client. So what makes one attorney-client privilege and the other not?
These communications with Dr. Burkhardt that we're talking about here, they are attorney-client privilege because they are necessary in order for Arthrex's attorneys to provide legal advice to Arthrex.
Wasn't it necessary for the criminal defense attorney to reach out to the potential witness?
Certainly it would be, but the nature of that relationship is different. We can't just, if we look at what the case law said, these communications are privileged. We have to think about, why are they privileged? What is the function there? The function of this relationship between the inventor and this company seeking patent protection is one in which they're working together in order to obtain patent protection for this invention. It's not as if we're talking to a neutral third party who has no role in the matter. The communication with Dr. Burkhardt is solely for the purpose of furthering Arthrex's patent prosecution process. And the parties knew this going in. That's the purpose of communicating, was to facilitate the patent prosecution process for Arthrex. And as we pointed out in our filings, this absolutely requires full and frank communications between Arthrex lawyers and its inventors. If we have a situation, which Dr. Burkhardt suggests now, where any communications between Dr. Burkhardt and Arthrex lawyers in the furtherance of seeking patent protection for inventions can be later turned around and used against Arthrex in litigation, it'll have a profound effect upon Arthrex's business and in a very negative way.
Mr. Bender, you've got about 30 seconds left to wind up.
Okay, Your Honors, we believe that there's no statute. Our briefing and our arguments in our briefings, we've established that these communications are protected by the attorney-client privilege. There's no statutory exception established by Dr. Burkhart, which would overcome that analysis. Furthermore, we're here on a motion to disqualify counsel. Under the Young v. Achenbach case, that is reviewed under an abuse of discretion standard. We do not believe that appellants have demonstrated or can demonstrate that the trial court abused its discretion when it entered the order disqualifying Kirkland and Ellis's counsel.
I did let you go over quite a bit, so I'm going to say thank you.
Thank you,
We're
Your
going to move
Honor.
over to Mr. O'Quinn. I think I said 5 minutes for you.
Thank you, Judge Valenti. So Judge Atkinson, you asked the question, what's the nature of the relationship between the parties here? And it's very straightforward. You have two distinct entities who have their own interests. Yes, they share a common interest, but two distinct entities with their own distinct interests represented by different counsel. And this fits. This is the classic case where common interest would apply. But there's a reason that Arthrex is resisting common interest, because they know that in a common interest setting that the privilege applies as to the outside world, but it doesn't apply as between the parties. And so they are trying to jam a square peg into a round hole when there is the square hole of common interest right here. And in doing that, they try to sort of say, well, there's something special about the inventor-attorney communications that makes this different. And respectfully, that's not true. If you look through the Federal Circuit case law that they cite, all the federal patent case law recognizes is that inventors are not disadvantaged. They're not disabled in their communications with attorneys. But that's presupposing that the attorney-client privilege exists in the first place, because there was a school of thought prior to the Federal Circuit rendering its decision in Spalding and in other cases that the information from inventors to attorneys isn't really privileged because it's just factual information. But there still has to be an attorney-client privilege in order for privilege to apply. And indeed, cases like the Rembrandt case that are cited in the briefing show that not all communications between an inventor and a patentee turn out to be privileged in the first place. And I think it makes sense then to take a step back and recognize that you do have this arm's length relationship, and that the nature of the documents that we're talking about are not documents that were given to Dr. Burkhart in some way, shape, or form, although if they were, that would just be a waiver. They are the communications with Dr. Burkhart. They are marking as privileged emails from Dr. Burkhart back to them, in which he is communicating with them. And again, that's if they make a policy point here about inventor and company relationships. No inventor on earth would enter into a relationship that would basically say that the counterparty gets the ability to use all of their communications against the inventor, but the inventor has no ability to make reference to the communications when he believes that there's a breach of contract. And the parties knew full well that litigation was a possibility. They put that into the agreement. They have paragraph 14 is a forum selection clause, and they knew full well that if they ended up in a dispute, that yes, they had kept things confidential amongst themselves, but that doesn't mean that they can't come out in the context of the dispute. I think the trial court here simply fundamentally erred as a matter of law. I think it erred out of the gate because I think it thought that this was an inadvertent disclosure case. I think that is reflected in the order itself. The very first paragraph says to, quote, return all of the privileged materials. That makes no sense. Nothing has been taken from Arthrex. Nothing was inadvertently given by Arthrex. And that ties back into the fact that the timeline here is decidedly not Arthrex's friend. It is not its friend in terms of it sitting on its hands when the Hush Blackwell firm was adverse to it at the same time that it was receiving the very communications that they claim with Hush Blackwell are privileged. If Hush Blackwell had filed the suit on Dr. Burkhart's behalf, I guess they'd be trying to disqualify Hush Blackwell, but that would make no sense whatsoever because they knew that they were adverse. And respectfully, the issue about counsel's conduct, of course, is ultimately not relevant because the legal issues here would resolve the case. But the timeline is not their friend either. The fact is that the records show, and you can look at Appendix 500 and communications thereabout, that every time they identified a document, Kirkland sequestered that document. And that was despite what was, I think, some unreasonable and overbroad demands in Appendix 535 to 538. They're not asking Kirkland to sequester specific documents. They're saying, stop look at any of Dr. Burkhart's production. Stop looking
Mr.
at
O'Quinn,
all.
you're at a half minute.
Thank you, Judge
Half
Valenti.
minute.
Stop looking at any of your own client's documents. And what did Kirkland do? Again, anytime they identified a document, Kirkland sequestered it, and Kirkland took the matter immediately to the trial court. So in any event, those issues are really extraneous because the sole basis for disqualification was the finding of an unwaived privilege. There is no privilege that applies against Dr. Burkhart. If it is, it has been waived, and we respectfully ask that the order be quashed. If the court has any further questions, I'm happy to answer them.
You're out of time, and thank you both very much. Well argued. That's going to conclude our session today of this OA calendar, so we'll be in recess. Have a nice day.
Thank you, Judge Valenti.